63. How do I communicate the employment at will relationship to my workers?
First of all, recognize that most states, but not all, recognize at-will relationships. For example, the state of Montana has enacted a statute that completely abrogates employment at will. As a result, Montana employers are prohibited from discharging workers without good cause. If you are in an employment at-will state, you can establish an at-will relationship with your workers by properly communicating their at-will status in employment applications, offer letters, and handbooks, and via freestanding documents, typically found in a new hire package. Sample language can be found in Appendix J. Please bear in mind that this is only a blueprint to save you time. Qualified legal counsel should approve the actual language you use. Prospective new hires and employees alike should sign these documents. Tell me more. Why do companies spend so much time drafting at-will provisions to protect themselves from litigious ex-employees? The answer is simple. In order to retain the at-will affirmative defense and win a summary judgment, companies are obligated to show that they've communicated clearly the at-will relationship to their workers. It's not enough simply to use the term at-will in offer letters and the like. Courts want to ensure that workers understand what the term at-will actually means, hence, the follow-up description with or without cause or notice at any time. In addition, some courts have denied companies' requests for summary judgments based on the employment at-will affirmative defense because it simply had been too long since the organization communicated the at-will relationship to the employee. In other words, courts have ruled that if a 20-year employee hadn't signed an employment application, offer letter, or handbook acknowledgement in as many years, the company's burden of communicating the at-will relationship hadn't been satisfied. That's why many companies issue annual at-will updates for their employees' signatures. Similarly, certain courts have ruled that at-will language buried in employment applications, offer letters, and handbook acknowledgments didn't meet the threshold of communicating the at-will relationship. Companies responded by creating freestanding documents that were to be signed and attached to employees' personnel files. As a matter of fact, courts have denied the employment at-will summary judgment when that relationship was solely communicated via the employment application. The court's logic? Employment applications were only enticements to enter into an employment relationship with a company. The employment applications themselves were not documents that govern the actual employment relationship once it began. So what's a company to do to protect its right to gain a summary judgment by using the employment at-will affirmative defense? The answer is simple: do as much as possible at all times. Communicate employment at-will language in employment applications, offer letters, and handbooks, and via annual freestanding at-will reminders.